Judgment in the appeal of Queen against Chaytor and others.
The three appellants face criminal charges of false accounting. These charges relate to claims that they made for allowances and expenses when they were members of Parliament. Their cases raised an important and novel question of law. Did the privilege enjoyed by Parliament prevent the criminal courts from trying them? Parliamentary privilege exists to protect Parliament from interference by the courts. For many centuries, the courts have recognised that there are some activities within Parliament into which they cannot inquire because they fall within the exclusive cognizance or exclusive jurisdiction of Parliament. In 1689, Parliament itself enacted, in Article 9 of the Bill of Rights, that the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. This prohibition covered much that fell within the exclusive cognizance of Parliament, but the boundaries were not clear. The question raised by this appeal was whether submitting claims for parliamentary allowances and expenses was part of the proceedings in Parliament or otherwise fell within the exclusive cognizance of Parliament. We unanimously decided that the answer to this question was no, and we gave judgment dismissing the appeals on the 10th of November, saying that we would give our reasons later. The reasons can be simply stated. Parliamentary privilege is essentially concerned to protect from interference the business that Parliament exists to conduct, in particular the legislative and deliberative debate and discussion that takes place on the floor of the Houses or in parliamentary committees. Making claims for allowances and expenses does not form part of this business. It is an incident in the administration of Parliament. Parliamentary privilege has never prevented the prosecution of members of Parliament for ordinary crimes that are not connected with carrying out the business of Parliament. For these reasons, Parliament's privilege will not be infringed by the prosecution of the appellants, and each will stand his trial.
Judgment in the appeal of Spiller and another against Joseph and others.
The law of defamation is not simple, as this appeal demonstrates. The law permits a person to write something about another that is derogatory, provided, 1, that it's a comment on a matter of public interest, 2, that it is based on fact, 3, that that fact is true, and 4, that the person making the comment believes that it is fair, even if it is not. This defence to a claim for libel has been described as fair comment, although we have suggested that it should be renamed honest comment. The law lays down one further requirement for the defence of honest comment. The person making the comment must indicate what it is he is commenting on. Sometimes it will be obvious from the comment because it refers to a matter that is in the public eye. If it is not, then he must state what he's commenting on. The issue in this case is how much detail he has to give. Lord Nichols, when sitting in the Court of Final Appeal in Hong Kong, dealt with this question in the case of Paul against Albert Cheng. He indicated that the person making the comment must give enough detail to enable the reader to make up his own mind whether the comment was justified or not. If this is correct, it's going to be quite a restriction on freedom of speech, especially in modern times when many people make comments on the internet which do not go into a great deal of detail. This is such a case. The defendants, who acted as agents for musical groups, said on the internet that the claimants, who were such a group, were not reliable because they'd not been able to abide by the terms of their contract. But they gave no details of the alleged breach of contract, so that the readers were not able to judge for themselves whether or not the comment was justified. Does this mean that they cannot seek to rely on the defence of honest comment? We have unanimously decided that it does not. Lord Nichols overstated the case when he said that the readers of the comment should be put in a position to decide for themselves whether it was justified. It is enough if the person making the comment identifies in general terms the factual basis for the comment. For this reason, we allow this appeal and hold that the defendants can seek to rely upon the defence of honest comment. Whether that defence succeeds will be determined at the trial.